Oh yes, oh yes, oh yes, the Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Tennessee Court of Appeals. If things feel a bit unusual, it's because things are a bit unusual. We haven't done this in a while, about 2 years as a matter of fact, so welcome back. Before we get started, I want to touch on a few matters just so we're all on the same page. First of all, I want to explain our procedure as we proceed this morning. Each side will receive 15 minutes to make its oral argument. If there is more than one party to that side, then we expect that you've made arrangements with each other and provided those to the clerk on how you're going to share time. We have with us this morning our clerk, Miss Angie Dempsey, and we appreciate her being here. Also, your panel this morning will consist of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before you call the first case?
No, Your Honor.
You may call the case.
Thomas Krajenta et al. Versus Volker Westphal et al.
And we will hear from the appellant.
Good morning, Your Honors. My name is Jonathan Miley. I'm here on behalf of the appellant David Mills. There are multiple appellants in this case.
I assume y'all have worked out how you're splitting
We
time.
have. I'm going to do 8, and he will take 7, and I will save 1 minute for rebuttal of my time. Is that what we agreed on?
You agreed on 7.
7. 7 and 1.
7,
Yes.
6, and 1.
7 and 1.
Okay. All right. You may proceed.
Thank you, Your Honor. There are 2 main issues I'd like to touch upon this morning during this oral argument. The first deals with the non-suit that was filed by my client, Mr. Mills. Rule 4101 was amended in 2004 to require that the court enter an order of voluntary dismissal after a plaintiff files his non-suit. The Supreme Court went on to address that amendment, and it stated a pro forma order must be entered by the trial court for ministerial and procedural purposes. This court further stated the non-suit actually occurs prior to the entry of the order. It is clear that taking a non-suit ends the plaintiff's action in a single plaintiff case at the time he or she files his non-suit. Thus, by implication, it should likewise be clear that in a multi-plaintiff case, the plaintiff who takes a non-suit only ends the action for himself on the date the non-suit was filed. Now, even assuming that Mr. Mills remained in the case until such time as the trial court entered an order approving the non-suit, arguably such an order was entered in the present matter. The trial court granted the motion to substitute counsel by order, which stated, and I quote, "Counsel for defendants and petitioners need not provide notice to either Malloy or Mills of future proceedings unless otherwise ordered by the court." Now, Mr. Mills, if in fact remained in the case, would have still been represented by Mrs. Malloy. Therefore, it is apparent that the court believed that Mr. Mills was no longer in the case, as he was not to receive notice of any further proceedings, nor was his attorney. The trial court effectively granted his non-suit by its order dated October the 29th, 2018. Now, there's no magical language that must be included in the trial court's order for the non-suit to be effective. A court speaks through its orders, and in the present case, the court entered an order that led Mr. Mills, his attorney, and the other petitioners to believe that he was no longer a part of the lawsuit. For the 5 months between when he filed his non-suit and when the defendants filed the objection, Mr. Mills did not participate in this case in any meaningful way as a plaintiff. Thus, Mr. Mills was out of the case when he filed his non-suit unless some exception applies. Now, the defendants claim that Rule 2306 is such an exception, and it states in relevant part, "In a derivative action brought by one or more shareholders or members to enforce a right of a corporation or of an unincorporated association, the action shall not be voluntarily dismissed or compromised without the approval of the court. Now, the term action referred to in the last sentence of the rule clearly means the derivative lawsuit itself. Rule 2306 only requires court approval if the entire action is being dismissed and not the claims of a single individual. When a non-suit dismisses the entire action, it is the members of the association who have the right to contest the dismissal, not the defendants. If the court concludes that it is not in the best interest of the association for the case to be dismissed, the court can refuse dismissal. Now, this is not an issue in the present case because when Mr. Mills filed his non-suit, it in no way affected the rights and claims of the association alleged in the derivative claim of the lawsuit. Also, and importantly, defendants argued in their motion to dismiss that Mr. Mills did not have standing to bring a derivative action under Rule 2306. Therefore, defendants are essentially claiming that petitioners Mills and Wagner, who are nothing more than homeowners in the association, have no standing to bring a derivative action, but likewise, they cannot dismiss their lawsuit because their non-existing derivative action requires court approval. The argument by the defendants on this issue simply doesn't make sense. The second issue I'd like to touch upon is the award of attorney's fees. Now, defendants were awarded a judgment for their expenses and fees under the portion of the derivative statute in the amount of $95,000. We would argue that fees cannot be assessed under this portion of the lawsuit because the court granted the motion to dismiss based upon the defendant's complete argument that the plaintiffs failed to comply with the derivative statute. Now, the court's rationale in the case of Kovacs-Whaley is actually applicable here, and I will quote the relevant part. It states, defendants argue that because plaintiff's intent was to pursue a claim under TCA 48-17-401, they should still be awarded their attorney's fees pursuant to the statute. This court stated, we respectfully disagree, having determined, as the trial court did, that plaintiff did not properly assert a shareholder's derivative action, and therefore TCA 48-17-401 is inapplicable, and defendants are not entitled to their attorney's fees pursuant to the statute. The same rationale is applicable in the current case. Defendants succeeded in their motion to dismiss based upon the argument that Mr. Mills did not properly assert or plead a derivative action. As such, the statute awarding fees under the derivative action statute is likewise not applicable. And then finally, defendants sought their attorney's fees under the portion of the statute that permits them if the court finds that the lawsuit was brought frivolously or in bad faith. However, the very next section of the statute goes on to state that if the proceeding on behalf of the corporation results in the corporation taking some action requested by the plaintiffs, the court may award the plaintiffs reasonable expenses. The first statute must be analyzed along with the second. The petitioners can use evidence of the second to refute the first. So if the petitioners can show that the association took some action that was prayed for in the complaint, then it certainly could not have been frivolous or in bad faith, and that's exactly what we have here. As we've set forth at length in our brief and reply brief, the association took a number of actions that were specifically prayed for in the amended complaint after the amended complaint was filed. Thank you.
Thank you. Yes, sir, please.
Morning, Your Honors. May it please the court, I'm Michael Rafferty. I'm here from Memphis along with my partner, Emily Ham-Husett, who did most of the drafting of the briefs, so if the briefs are any good, they're because of Emily, not me. As Mr. Miley stated, we have divided up our time. I have 6 minutes on my presentation as the co-appellants here, and I believe that'll be adequate for me for what I have to say, but I invite the court to, as the court can do anyway, but if you have any questions, I'm happy to answer them. Your Honors, rather than reiterate everything in our briefs, because the court can read it as well as I can state it back to you, I would like to focus on just two principles that I believe are applicable here. And one of them is a fundamental one, that a court cannot add words to a statute. It may only apply the words of the statute as enacted by the legislature. Justice Scalia, the late Justice Scalia, was on the bench in 1986, which was 4 years after I graduated from law school. But he had a profound influence on advocacy and the way courts and lawyers argue and present cases based on statutory construction. When I was in law school, we heard a lot about legislative history, but that's now just a relic of the past in most cases. Tennessee Supreme Court has for its entire existence focused on the fact that the courts are to apply the laws as written by the legislature. And why that's important here is that every issue that we have is a legal issue that requires appellate review de novo. Because our position is the trial judge got this wrong under the law because he read things into the statute that weren't there. The order on the granting the attorney's fees to the defendants, the one July 8 of 2021, it appears in the record in volume 10, beginning at 1427. But in particular, on page 1431, the court makes the determination that he is awarding attorney's fees to the defendants because, among other things, it says the plaintiffs continued aggressively to litigate the derivative action. And then he goes down further and he says, upon finding that plaintiffs commenced and continued this proceeding frivolously and in bad faith. I want to focus on the fact that the court says that they continued to aggressively litigate it and that they continued to do so. Well, that's not what the statute allows him to award attorney's fees on. The statute says that that it is focused on whether an action was commenced, which means anything post-filing wouldn't have any bearing on that. There are some cases, and I'd like to submit this to the court on supplemental authorities, but there are statutes in Montana, Michigan, and Utah that bear this out, that on this same kind of statute say that you can award attorney's fees for an action that is commenced or maintained. That's the language in Montana. In Michigan, it says that if the expenses are incurred in defending, and the Utah one says the same thing, incurred in defending. So in other words, if there was a broader allowance, that would be okay. But the Tennessee statute says it's when it's commenced in bad faith and frivolously. We submit that there's no it's not appropriate for the court to have entered an award in any event, and it is certainly incorrect in awarding fees based on what happened in the litigation once the action was commenced. The other principle that I want to talk about relates to that same thing, and that is that parties in a private party contract cannot change the words of a statute. And that's what the defendants are arguing here, that even though the statute says that the fee award can be awarded for expenses, or excuse me, the language of the statute says the defendant's expenses incurred in defending the suit. It is the defendant's expenses. Everyone concedes, the court made in its order of July 7, or July 8, I think it is, I'm sorry, July 8. It said that that it acknowledged that travelers had a right of subrogation. Well, that right of subrogation appears nowhere in the statute. It is in their contract. Well, that has nothing to do with what the statute says. The court wasn't authorized to take into account what was going on with the travelers and the homeowners association defendants. I'm getting close to the end of my time, so what I would like to say, though, is I want to reiterate that if the court will follow what the Tennessee Supreme Court has said and just simply apply the law as written in the statutes and in the rules that are applicable here, this order must be vacated and the case be sent back to the court to comply with that. It looks like you were getting ready to say something.
Let me ask you about the award of attorney fees under the loser pay statute. What do you say about that?
Your Honor, there are multiple problems that I submit, and we put them in our brief, but the main thing is, one of the things it says, there are two things, I say main things, there are 2 points that I'd like to make here. Here, the plaintiffs made several attempts, and there's a declaration of Kim Wagner in the cited in our brief, but it's in the record, where he points out that they made several attempts to settle with the defendants, and the defendants never once responded, never. That's one thing. The second part of it is that they tried to non-suit this case, but the court wouldn't allow them, and the defendant opposed it as well. So under the loser pay statute, I don't think any of it would apply here because of the fact that these pro se, and I may have overlooked one important point. Those principles I just mentioned, or those rules, or factors rather, apply when you have a pro se plaintiff, and that's what these were, at least for the commencement of this and for a good portion of the case. And so that would be our position. I don't know if I've answered you.
I don't know that you answered it. In regard to the motion to dismiss that was granted, and there was award of fees under that statute that allows for an award of fees where the defendant is successful in a motion to dismiss. What do you say about that award? I mean,
because the fact that you have to go back up the trail to say that, well, the only reason the statute would even come into play was because the plaintiffs were not allowed to take a non-suit. So
was a trial court required to act on the non-suit before acting on the motion to dismiss?
I submit that that's the way the rule and the statute work together, as Mr. Miley was saying. And I would say too, if you look at our motion, or rather our notice of voluntary dismissal, Ms. Huseth anticipated this and put explicit discussion of what are the concerns in the statute, which is applicable. There's no doubt about it that the statute would apply, that the statute on derivative actions for a non-profit corporation. But the concept there in the statute is that they are to give notice, that the court is to oversee and make sure that any interested party would get notice because of this representative capacity.
Let me make sure I understand what you're saying. What do you cite as authority for your position that the court should have acted on the non-suit before ruling on the motion to dismiss?
It's it's our notice of voluntary non-suit, Rule 41, and the derivative action statute itself. As Mr. Miley pointed out, there is a case on the for-profit or the business corporation statutes that says that if the conclusion of the court is to dismiss something, miss a derivative action because it wasn't even in a valid derivative action, then you can't award attorney's fees under that circumstance. But I would submit that you don't even have to go that far. You just look at the statute that's applicable and see that the need for the court to oversee or approve a dismissal, a voluntary dismissal, which is simply to make sure that there are interested, affected parties who are getting proper notice. And that just wasn't an issue here, because the defendants were arguing this case needed to be over with, and that's all the plaintiffs were trying to do. This wasn't going to affect any non-interested, or rather interested party who was not named, because that's what these are all about, those class action statute, the class action rules, and any statute where you're acting in a representative capacity. If the nominal party is going to dismiss the action, the court wants to make sure, and the legislature told them to make sure, that anybody who was affected by their representing them or in their representative capacity, that they get notice to be able to comment.
Thank you.
Thank you.
Does that answer you? Thank you, Your Honors. And I've reserved 1 minute for rebuttal, I believe.
Hear from the appellee.
Good morning, Your Honors.
Morning.
Canon Allen for Riverwood Farms and the 4 individual board member defendants. I want to first address what's not before the court. The motion to dismiss and the granting of the motion to dismiss, although it was raised as an issue by Mr. Mills, is not properly before the court. Mr. Mills waived any claim regarding the motion to dismiss. He waived it in his pleadings before the court. That can be found in volume 9 at, I believe, page 1212, where Mr. Mills specifically stated that he was withdrawing any claim that he had that the court had improperly granted the motion to dismiss. Secondly, this is not a 4101 case. This would be a 4101 case if Mr. Mills had personal claims that he was asserting. And Mr. Mills says in his briefing that, in fact, there are personal claims that he was asserting. But in fact, in the first amended complaint, this is volume 2 at page 210, paragraph 4, all petitioners are also general members of the association and bring this action derivatively on behalf of the association in their capacity as general members. And then he goes on, the petitioners go on paragraph 6, the action is a derivative action brought under 48-56-401 et sec, under the nonprofit statute. So this is not a 4101 dismissal. This could only be a 2306 dismissal because it's a derivative action. And in that case, the court has authority to exercise its discretion as to whether to permit the dismissal or not on motion for a non-suit. Now, in this case, importantly, Mr. Mills gave notice of a non-suit, but he didn't actually move the court for permission to non-suit, and no order was entered granting him a non-suit. The same could be said for the rest of the plaintiffs in the case. They filed a notice, but they didn't actually receive permission for their non-suit. With regard to the
Before you move off that, counsel, was this a proper derivative action?
Your Honor, we contend it was not a proper derivative action. Plaintiffs, and we contend that when they originally filed it, it was pro se. They sued for a receiver. There was no allegation that Riverwood Farms was in financial distress. In fact, in the First Amendment complaint, they alleged that Riverwood Farms had plenty of solvency. They also sought injunctive relief, but they didn't allege any irreparable harm. They sought a declaratory judgment. And we said in our motion to dismiss that they couldn't file a pro se derivative action. They then cured that with Ms. Miley when they brought her on as counsel. Nonetheless, we said their claims for receiver were dismissible, the claims for injunctive relief and declaratory judgment, all of those things should have been dismissed. Plaintiffs contended.
Let me ask you, you argue it was not a proper derivative action. I think the trial court, in effect, also found that it was not a proper derivative action. That being the case, why wouldn't the logic of COVAC apply here?
Yes, Your Honor. First, Coex Whaley arises under a different statute, and I believe perhaps the most significant distinction between the two is that Covax Whaley actually involved substantial personal claims that Covax Whaley brought against the corporate entity Wellness Care Centers, I believe was the name of the company. But particularly the court, in ruling on Covax Whaley in footnote 7, made the observation that the statute provides that the company is entitled to attorney's fees if the trial court finds that the proceeding was commenced or maintained without reasonable cause or for an improper purpose, and there's no indication of that in this action. Our contention, as we briefed in our papers, is that Covax Whaley is factually distinguishable, it's legally distinguishable, it's not the same statute, and that the statement by the court saying, well, because she failed to verify the complaint, therefore the case should be dismissed. The case was not proper and fees could not be awarded. In this case, the complaint was verified, although they failed at the outset to have an attorney, which they were required to. They subsequently obtained an attorney to cure that particular problem. Therefore, at the time that the court dismissed the action, there was pending before the court a derivative action. It had been amended and they now had counsel. And so they had cured that problem. And so we say Covax Whaley is not applicable because at the time that the court ruled on the motion to dismiss, it was properly pending before the court as a derivative action, although it was because it asked for legal relief that it wouldn't have been entitled to get, it should have been dismissed.
But in the trial court's ruling, the trial court is not dismissing the original complaint. As I read the order anyway, he's dismissing the amended complaint. And he says it's not a proper derivative action. I mean, he doesn't say why he says that, but that's what he says in the order.
Your Honor, I believe at the time that the first amended complaint was filed, which would have been in early June 2018, they did not have Ms.
May
Malloy.
4, 2018.
May 4, thank you, Your Honor. They did not have Ms. Malloy on board as counsel. She wouldn't come on board until June. But at that point, they cured that procedural issue. As it relates to the merits of the claim, we argued, and I would note, the plaintiffs did not oppose us. By the time we got to the argument on the motion to dismiss, the plaintiffs had withdrawn their brief. So there was no opposition to the motion to dismiss at that point. And so we contend that when the court granted the motion to dismiss, the court properly did so at that point because the plaintiffs had withdrawn any opposition to it. Under the circumstances, we believe that the court properly dismissed the case because of withdrawn objections to the claims, and the court properly determined that the plaintiffs had commenced the action frivolously and in bad faith. I want to address just for a moment counsel's argument that none of the conduct by the plaintiffs subsequent to the filing of their claim should be considered in determining whether the action was commenced in bad faith. The court found 13 different findings relating to frivolous and bad faith litigation. And I would argue, just as a matter of the court's discretion, the court ought to be able to take into consideration how the plaintiffs proceeded forward with their complaint in order to determine, well, what was their motivation at the time that they filed their complaint. And the findings of the court are striking. As soon as the complaint is filed, the plaintiffs attempted to prevent the association from notifying the homeowners. They attempted to prevent the association from filing an insurance claim. They attempted to keep the association from retaining counsel. They even filed a disciplinary complaint against one of the attorneys that represented the association. And
Let me ask you a question, counsel. Were these factors that the court found in its order of July 2021 in the attorney fee order, were those factors stipulated?
Your Honor, in fact, everything that I just said, the court had firsthand knowledge of because there were motions that were pending in front of the court. But not all
Okay,
factors
let me
were
stop you
stipulated.
there. Motions pending before the court. What do you mean?
Almost as soon as the complaint was served, the plaintiffs went to court in order to keep the association from from tendering its claim to its insurance company and hiring counsel. And so there was a motion pending in front of the court. The court resolved that motion, denied the motion, but the court had firsthand knowledge with what the plaintiffs were doing at the outset of the case in order to deprive the association and eventually the defendants. But at that time, it was just the association of representation.
What I'm trying to ascertain is where this evidence that the court supposedly made findings on derived from. Was there an evidentiary hearing?
There was not an evidentiary hearing.
Was there ever an evidentiary hearing in this case?
No, Your Honor, there was no evidentiary hearing in the case.
Or how was it litigated? Was it by affidavit?
Declarations that were submitted once the court made its ruling with regard to the motion to dismiss. The parties then submitted declarations to the court. The association and the 4 board members submitted declarations in favor of the motion for attorney's fees and expenses. And notably, Your Honor,
So was this evidence undisputed?
I believe, Your Honor, that in fact, the declarations that were submitted in the case were not disputed. The plaintiffs did not dispute. They attempted to keep the association from hiring or from submitting an insurance claim, hiring counsel, and they had those declarations. They did not dispute that they had attempted to recruit Michael Poindexter as the 4th board member who would run for office, and then they would have a majority on the board. They didn't dispute any of that. What they did dispute, Your Honor, is they said, well, this lawsuit caused the association to do things that it was not otherwise going to do.
Is that true?
It's not true, Your Honor. That is disputed, and we disputed it in the declarations.
So the board did not implement any of the things that were raised in the original lawsuit and admitted complaint that was complained of by these plaintiffs.
I want to make sure that I answer your question carefully. There was an engineering survey that had been done back in 2012. They then, and the plaintiffs admit, they collected money. The association collected money over a period of time in order to implement those things. Beginning in 2017, that process began. That process continued on through 2018 and 2019, such that plaintiffs could look at it and say, wow, post hoc ergo propter hoc. They did this, it must have been because of us. The declaration of Paul Westphal makes it plain that there was a plan and they were implementing the plan, and it took place over a period of time.
What do you say about this language in the order where the judge says that some of the issues raised in the original and amended complaint were worthy of board consideration? What is?
Your Honor, I believe what he's referring to is that the first amended complaint is essentially an argument that the plaintiffs in the case had better ideas on how to run this neighborhood. It's a large neighborhood with a lake. They had better ideas on how to run that neighborhood than the board members did, who were actually empowered to maintain and operate this neighborhood. And I believe that what His Honor meant by that was the plaintiffs, there's a forum for this, and it's on the board. And if they have issues with how the place is being run, they need to go to the board. They don't need to come to the court and say, you all are doing this incorrectly. It's not a matter to be litigated. I think that's what he meant, Your Honor. If there are no other questions, I would like to cover just one other issue briefly, and that has to do with the $2,500 limitation. It wouldn't make sense, we argue, for the association who has obtained insurance to be penalized such that they couldn't recover their fees and expenses for frivolous and bad faith litigation. Thank you.
Thank you. I think each of you have 1 minute in rebuttal.
So very briefly, I just wanted to touch on a few things. I think it's important to remember that there were two different categories of appellants, of petitioners here. You've got the actual board members who had the authority to bring a derivative action, and then you had the 3 homeowners who did not have standing. Now, this was a pro se filed complaint, and so there may be some issues with some of the wording in there, but just because a person claims to have standing or was combined with a person with standing does not mean all of a sudden that they have standing. There's no doubt that Mr. Mills and Mrs. Wagner had no standing to bring a derivative lawsuit. Now, I also think it's important to look at the order. Now, is that the trial court doesn't substantively address any of the evidentiary statements that are found in these warring declarations by the different sides. And I think that's really important. That's really all my time, if you have any questions.
Thank you.
Very briefly, Your Honor, as to the question of whether this was stipulated or facts were stipulated, they were contested. I refer the court to page 30 of the co-plaintiff's, co-appellant's original brief for the citation in the record of the first declaration of Kim Wagner and the second declaration of Kim Wagner. These are most certainly disputed items, and there was never an evidentiary hearing of any sort. I'm not sure how the judge would have had firsthand knowledge of anything other than what was in the record, which of course that is certainly true, but things that the board did or the alleged actions supposedly taken by our clients were not in front of the court. Last thing is 17 items were attached as an exhibit to Mr. Wagner's one of his declarations. I think it's his first one, but that's in the record. Thank you, Your Honor.
Do you concede that in your statement of issues, you don't raise an issue regarding the motion to dismiss or the grant of the motion to dismiss?
I'm sorry, Your Honor. I had trouble hearing you.
In your statement of issues, is the motion to dismiss an issue on appeal?
Well, it has to be. I mean,
Well, no, I just want to know in your statement of issues, is it?
well, it's part of our position that the motion to dismiss shouldn't have been considered by the court because the case should have been dismissed pursuant to our voluntary non-suit.
That's your statement of issues about the trial court's refusal to grant the non-suit. But in your statement of issue, do you raise an issue about the court granting the motion to dismiss?
I'm not sure I'm following. Are you asking, are we arguing or raising an issue?
I know what you're arguing, but in your statement of issue, do you make that an issue on appeal?
The only way I can answer that, Your Honor, is that it's implicit in our position that in other words.
Implicit but not specifically stated? Is that what you're saying?
I would say that's accurate, Your Honor.
Okay.
Mr. Rafferty, I have a question. With regard to this traveler's issue, is there a collateral source concern there?
I'm sorry, Your Honor.
Is there a collateral source concern with regard to this $2,500 payment with regard to travelers?
If there is, Your Honor, it certainly isn't in the statute. And that's our position, is that the statute is as clear as it could be, that it's the defendant's expense. And what was the defendant's expense? It was the only expense they incurred was paying their deductible. And I would say that they go hand in glove in terms of the fact that what travelers and the Homeowners Association are trying to do is say, and Mr. Allen said it straight out, that they view that they are being penalized because the insurance company isn't going to be reimbursed for what it incurred. Well, it had a contractual obligation to defend. They were just doing what they were required to do under their contract. They're in the business of providing insurance coverage that has two elements to it: indemnity and a duty to defend. So they were just doing what their contract provided. You know, the Eighth
I
Circuit.
think you've answered the question.
I'm sorry? I did?
You want to follow up on that?
Well, one
Thank you.
follow-up.
Okay.
You concede then that the $2,500 was an expense incurred by the Homeowners Association?
Oh, yes. I don't
Okay.
think we could dispute that.
Okay, all right.
But I would say that's not our only position on that, of course. We submit there are other issues.
You've answered his question.
Thank you, Your Honor.
Thank you. All right, we will stand in recess to the call of the next case. Ms. Angie, if you'll recess court to the call of the next case, please.
All rise. This honorable court is in recess until 11 a.m.